if you'll please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, notice is hereby given that if you're not satisfied with the decision made by the Metropolitan Transportation Licensing Commission, you may appeal the decision by petitioning for a writ of certiorari with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Metropolitan Transportation Licensing Commission's decision. We advise that you seek your own independent legal advice to ensure that your appeal is filed in a timely manner and that all procedural requirements have been met. Prior to today's meeting, Mr. Fields circulated the minutes from last month's meeting. Is there a motion regarding approval?
Motion to approve. Second.
All those in favor?
Aye.
Motion passes. Next item on our agenda, as many of you know, the Metro Council has passed a new bill to govern the SUMDs in the county. As part of that bill, which we're anticipating going into effect, this commission needs to conduct and determine appropriate fees for SUMD permitting, and we need, as a commission, to authorize a cost study so that Mr. Fields' office can conduct that cost study, and so we need to talk about that and decide if we. I mean, I don't think there's really a choice. We've been mandated by the new ordinance to determine the appropriateness of new fees, and I think the only logical way to do that is to do a cost study first to figure out what amount of fees need to be charged in order to offset the increased costs for regulating the SUMDs.
Mr. Fields, the office at this time already has a fee in place, does it not?
Well, there was a fee in place. The new ordinance, however, I think probably throws that out. So so that's part of what we're going to have to do is establish the new fees.
Just using that fee as a base, how far over that in cost are we?
Probably several $100,000 more that would actually do what we're doing today.
So, with that in mind, as a suggestion, knowing what the fees are and the costs that you've incurred, what would you say is a baseline that as an estimate that increase would need to be?
I think part of it's going to come back to the policy on enforcement. I think we have a pretty good idea from a staff standpoint in the Transportation Licensing Commission. I think we know about how much time it's taking us. We have a reasonably good idea in Metro Legal. We have a reasonably good idea in Metro Public Works, in engineering, as well as some administration. And we also have a good idea on Metro IT. I think where the problem would come in is the enforcement levels, and I think that's going to be a policy issue of what level of enforcement do we want and how do you want it enforced. Is it police officers on the beat? Is it some sort of an enforcement officer that's on the streets? So I think that's part of what we'll have to do is to work in-house, potentially work with a consultant to put together a model, do a little research around the country as well, and come back with a model that would be presented to the commission. It could also be a part of the RFP, but would have to, again, that's, so I'm a little hesitant to say what a baseline would be. Again, I can give you generally what we think we're spending in terms of staff time. But, I mean, in my case, I'm spending well over 50% of my time working with SUMDs. We have in the office, Ms. Stillman's probably working anywhere from 10 or 15 or 20% of her time, just depending on what it might be. Then we also have one more, Erin is probably spending up to 50% of her time, depending on what's going on with complaints, forwarding those complaints and photographs, and then logging the photographs and the complaints to make sure that we're actually keeping up with it. From an IT standpoint, they're probably having more than one person full-time working on this in various capacities, putting together reports and then gathering the data that's coming in, and it's coming in volumes. Public Works Engineering spent many hours evaluating, for instance, corral issues, and then not only the corral issues, but then we're now working on signage issues, on how would we put signage around downtown. So that alone is taking hours and hours and hours. So that from a cost standpoint, we just, we calculate how many hours are being spent, and I didn't mention Metro Legal. And an amazing amount of time that is spent, doing what we're doing. So then it goes, how many, if you want to enforce downtown, for instance, if you want an instant response if we end up with an instant response to an ADA claim, that means that 7 days a week, 24 hours a day, we're going to have somebody on the street available to immediately respond to an ADA claim. Well, if you look at this from a staffing standpoint, if it were to be a Metro employee, and it wouldn't necessarily have to be, but if it were an employee, you're talking about, the least you're going to have is probably 4 people in one position to be able to, and maybe 5, depending on. So it becomes just an amazing. The good news is good news for us, not necessarily for the SUMD companies, if there's a limited time, then let's say dawn to dusk days or the 10 to 6 that the council recommended. It would reduce the amount of time, but it's still several hours somebody would have to be. So I think those are the sort of things that are going to have to be worked through on the RFP. And if we can put the study together on the fees, if you'll authorize the study, then we should be able to come back and have recommendations. Again, I think it'd be a combination of staff and potentially consultants to give you a really good idea about what it would cost. And if you want this, it will cost. It's kind of like put a menu together for you. So this is your bare minimum. This would do this, and this would do this, and this would do that. So
the recommendation from the board would need to be just to authorize the RFP.
Today, that's all.
I can read you the language from the substitute bill if that would help. So that's Substitute Bill 2019-1658. It says, in addition to any regulations the MTLC believes are necessary for the safe and efficient operation of an SUMD fleet within Metro, including but not limited to establishing additional fees it determines are reasonable and necessary to carry out and enforce the ordinance. So in June, you all, as a part of your required report to council under the original code section 1262, you made a finding that the existing fees do not cover the costs of the metropolitan government currently. So I think it's kind of to fulfill that new language and kind of be based upon your finding in June that you would authorize this cost study.
Well, some of the information we've already gathered as a staff. In other words, we've identified where effort is being made, where time is being spent. So the good news is we already have started gathering that. I think, again, if funding is available, I'd recommend that we look and see who might be available as a consultant to advise us using Public Works as the engine to make that happen.
If you make your motion broad enough, it could include both options.
Wouldn't Metro Finance, they know for instance, the cost of an FTE of a particular position and that sort of thing?
And they would be, again,
finance probably together.
Mm-hmm.
Human resources and finance
together.
So they would participate.
Absolutely.
Or something, okay. Yeah.
Well, I think we just need a motion to, I make a motion to authorize, is it the RFP?
No, the
Cost study.
Oh,
Cost study.
make a
which
motion.
is separate.
To authorize a cost study to be done to determine the appropriate new fee amount for the SUMD permitting.
I'll second that motion
Second,
if
thank
it's, that's all you want to put in it. Did you say we had to put in if we wanted to use a consultant or anything? Didn't you just say that?
I would say leave it vague, then it could work either way.
Okay. I second that.
With the second from Ms. Palmer, all those in favor?
Aye.
Motion passes. Next up for discussion is a consideration by the Metropolitan Transportation License Commission to delegate authority for the appointment of an advisory committee to assist in advising on the preparation of a proposed draft RFP for the selection of a limited number of operators to operate SUMDs in Metro Davidson County. And I think the idea behind this discussion is under the new substitute bill, the council has directed the Metropolitan Transportation Licensing Commission to implement an RFP process. Obviously, as a volunteer commission, we're not necessarily expected to draft the RFP. We're certainly going to be working with a lot of other metro agencies to help actually formally prepare the RFP and also to guide us in the content of it. But I think it does make a lot of sense for us to be create a committee of advisory people. And Mr. Fields can comment on this because I know the reason why this is on the agenda is certainly as our director, he has some ideas of important stakeholders that would makes logical sense to be on this committee to help ensure that the policies and the reasons for the new bill the Metro Council passed are taken into account, and in order to prepare a really well thought out and reasoned RFP.
In the last several weeks, since it became apparent that we were going to be doing an RFP, we started thinking about how would be the best way to prepare it. Knowing that the commission can't do it, in other words, for instance, the many meetings that it would take, the public meetings, the TV cameras, the whole works, to be able to put together an RFP would be challenging. The role, I mean, it has to come back to the commission because it's your RFP. So it's not that we'd be putting an RFP together and saying, okay, we're done. It basically, we would design it, bring it back, and then in a public meeting, you'd have an opportunity to deal with it. And that could be changing it, modifying it, accepting it, refuting it, whatever that your action would be. We thought that in terms of stakeholders, we did think that a member of the commission would be appropriate for it, obviously somebody from commission staff, but Public Works, Metro Planning, IT, the police department, the Metro ADA program, someone from the Mayor's Advisory Committee on People with Disabilities, someone from the Mayor's Office, Walk Bike Nashville representative, a Vanderbilt University representative, either from the university or the hospital, but someone, since they've been dealing with this for months and months and have been advising us, as well as somebody from the business community. Of course, Metro Legal and Metro Finance and Procurement and others will be a part of the advisory part, all the way to Metro Claims, trying to make sure we're covering insurance and that sort of thing. So that would be the direction we would go if the commission agreed.
All those agencies agreed to do it, or
All of them had already been a part of the program,
Okay.
the process, one way or the other. Yes.
Okay.
I think the ones that obviously we've not gone into the business community and said we want, because again, that'd be a little presumptuous. We did speak with agencies saying, you're going to have to be a part, and no one's backed away from it. So I think it's just a matter of putting it together and then seeing what we can do in the next 30 days to try to bring you something back by the end of August.
Okay.
I mean, and that would be our goal.
Has the bill been signed yet?
It is not.
It is not. So it's not. Is it 100 days?
It has to, well,
It's 100 days from the effectiveness, which,
W-
if it doesn't get signed, it'll be August 6th is when it starts.
Okay. And did you anticipate some kind of public hearing? Did I say, just say
I
that?
think the commission, one of the things I would look for direction from the commission, you had mentioned during your deliberations over the last couple of months that you would like to have a public hearing or a public meeting. You wouldn't have necessarily have to be, if it's a hearing, then you're obviously going to have to convene. But if you were to direct the RFP committee to have a public listening opportunity where people could come and speak, that committee will do that.
Yeah, that's more appropriate than us listening to it.
Well, we'd encourage y'all to be there, of course, but we'll have to speak with Channel 3. We might invite them to film it. We certainly like to be on TV.
So does the motion just have to be for us to delegate authority to your office, to the staff, or?
So, Billy just sort of made a recommendation, so I think your motion could be to delegate that authority to be used as described by Mr. Fields, or consistent with what his recommendation to you.
Luckily, you are Kate.
And I've got a list of some ideas here, so.
Well, I will make that motion to delegate authority as just explained by Mr. Fields, to be used as described.
Second.
All those in favor?
Aye.
Motion passes.
Thank
Uh,
you.
Next item on our agenda, we've got a complaint. Actually, it's a continuation of a complaint that we were handling at our last month's meeting from a complaint from Susan Pizzatola against Nashville Pedicab doing business as Nashville Bar Bike, and as well as 2 additional complaints that Ms. Pizzatola has now filed. Mr. Fields.
We had gotten to that point. We had gotten to that point in the last meeting to be able to, where you had gathered your information. And at that point, you were beginning a deliberation on what actions you may choose to take. You were just at the point where I think that was going to begin. I had asked you to defer action to make sure Metro Legal had time to review and be present. Since then, the 2 additional complaints were brought to the commission along the same lines. So we presented those to you, and also had shared that with the Nashville Bar Bike folks. So there's additional information beyond what was discussed last month with the 2 additional complaints. Nashville Party Bike also is now represented by counsel, and they're present.
Ms. Pizzatola, do you have counsel as well? No. Would you like to come forward? I'm going to let you go first, but I'm going to swear you in.
Yes, sir.
In fact, Mr. Haynes, you have witnesses you anticipate?
Yes.
If everyone would stand who's planning to testify, and please repeat after me. Raise your right hand. I swear or affirm that the testimony that I'm about to give
I swear and affirm about the testimony I'm about to give
is the truth, the whole truth, and nothing but the truth.
is the truth, the whole truth, and nothing but the truth.
Thank you. You may proceed.
Okay. I know that you'd left early the last meeting, so I'm assuming right now we're talking about the continuance of last meeting.
Yes.
Okay.
And if I would appreciate a kind of a recap.
Yes,
of what
yes, sir.
happened.
No problem. Okay, so what I had briefed them on last meeting, and my complaint is in August 24th, 2018, Mr. Dustin Olson, a member at that time of the Nashville Pedicab LLC, requested to surrender his 20 pedicab permits in exchange for 2 6-passenger pedal carriages. You granted him that day, and I believe around 1st of May, his bike by the name of Nashville Bar Bike showed up on the streets of Nashville, and it is a 15-passenger bar bike, which is not what he was approved for. I notified Mr. Fields immediately, and he asked that I, file a complaint and bring it to the board's attention, and that's what I did. The last meeting, Mr. Patrick Lynch came and represented the company, and he mentioned to you that he tried or he did purchase 6-passenger pedal carriages, and they did not operate, and he had numerous issues and problems, yada, yada, yada. So he just went ahead and bought the 15-passenger bike, which he happened to purchase it from my same supplier, builder. It is the exact same bike as my bike, just a different color. And then basically, he made the decision on his own to purchase this 15-passenger and put it on the streets, ran the paperwork up through the TLC, and Mr. Fields' office and them did not catch it. They did not catch that he had a 15-passenger bike that he was not approved for, and he was issued a permit. Since the last meeting, I found a little more evidence here. So when he stated about he could not locate a 6-passenger pedal carriage and all the problems and issues he had, his lawyer presented me a folder yesterday by chance. And in that folder happens to be an invoice, which he did state, and I think showed you last meeting. He purchased 5 6-passenger pedal carriages. His misfortune with the pedal carriages, the breakdowns, all that stuff is irrelevant. He was issued 2 6-passenger pedal carriages, and that's what should be on the streets, not a 15-passenger just because you chose so. I'm going to pull up a picture here that his lawyer supplied to me, if I may approach. These are the 5 he purchased. Okay? If you look at the invoice, he purchased these, which is kind of funny to me, but he purchased them on 23 January 2018. He was not approved for 2 6-passenger pedal carriages until August of 2018. So that shows me he had this purchase 8 months before he was ever approved for 2 pedal carriages. And again, the issues with the pedal carriages is irrelevant. Then I went on into some more paperwork that was sent here, and it looks like from the get-go, they purchased the 15-passenger bikes, and the emails to the suppliers dated in October of 2018, November 2018, and this is a Rob Lynch. I have no clue who he is. I am looking to purchase 2 party bikes. The supplier here only sells 15-passenger bikes. So their whole intent was always to get the 15-passenger bikes, I feel like. I may be wrong, but the emails here shows it. I honestly think that the right thing would have been to notify Mr. Fields or come back to the board and say, if you couldn't find the 6 passengers or they didn't work or something, and, present it to the board. But either way, he was approved for 2 6-passenger pedal carriages, and that's what I feel like he should be operating at this time.
And now you brought 2 additional complaints, I
Yes, sir.
understand. Are they on the same issue or distinct issues?
Well, they're really close to it, sir. Doesn't have to do basically with the 15-passenger. I can't put my finger on it, I'll be honest with you, but social media is wonderful. Love it. Obviously, for my next complaints was, I honestly don't believe that Mr. Lynch had a, what's the word I'm looking for, was not a representable person to be representing the company. And what I'm meaning by that, if you go into the records of, I went to the State Department, and if you look up the Nashville Pedicab, LLCs, they're in there every year, and for some reason they keep changing their members and their agents between Dustin and Mr. Lynch and back and forth. And the interesting thing is, I'm going to read a statement here to you real quick, if you don't mind. Members, officers, employees, and managers of an LLC are allowed to act as the company's registered agent as long as the individual has a residence or office in the same state where the LLC is created. Hold that to mind for a moment. Mr. Dustin Olson, who came and did the exchange and created the request for the give up the pedicabs for the pedal carriages, he is no longer a member or anything to do with the company, basically. He no longer works for the company. He moved back to New Orleans and gave the management up to Mr. Lynch. Mr. Lynch, who also lives in New Orleans, states and does show on paper that he is the owner/member of the LLC Nashville Pedicab DBA Nashville Bar Bike on paper. So the two permits you gave and approved last August went to two people who doesn't even live in the state of Tennessee. And when you go to the Department of State and you pull up their filings and their LLCs and stuff, at the time of the permits and all this other stuff going on, Mr. Lynch and Mr. Olson both resided in the state of New Orleans, Louisiana. Since then, they have went and filed again. They did another change of agent with the LLC, and at this time, they've given it to a Miss Haley Hunt. They did change the address to Nashville. So I went doing a little more research and digging and stuff, and Mr. Lynch honestly is doing a great job, fantastic job, keeping his paperwork current in the state of Tennessee while living in New Orleans. And when you go back and look at his paperwork every year he submits, even the state seal of the notary is New Orleans. Today, I know that Miss Haley Hunt is going to tell you she manages this business for him, but I'm going to show you some social media here I have, and some other news I have. So on the LLC, it states Miss Haley Hunt is a member and agent now. Her fiance of Kyle Thompson and her was in Mr. Field's office on August 19th of this year, and they introduced herself as the owners of the Nashville Bar Bike. April 4th, Kyle, he posts on Facebook, "Hey y'all, if some of y'all don't already know, my beautiful fiance Haley Hunt and I have moved to Nashville to start a bar bike company together." What is a bar bike? It's a bar on wheels that seats up to 15 people. Yada, 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 yada. On and on about it on Facebook. So I go over and I go to Haley's Facebook, April 4th. "What's up, y'all? I am extremely excited about this new adventure in my life with my wonderful fiance, Kyle Thompson, but we need your help. Please like and share our business page, Nashville Bar Bike." Goes on and on. What is a bar bike? It fits 15 people. She also talks about it and explains it. So you go in and I read her reviews. April 4th. I won't say the person's name. She says, "These two owners are two of the most charismatic, fun, and incredible people I know. Haley and Kyle really bring the essence of New Orleans to Nashville. If you're looking for a good time, yada, yada, yada." On down. April 4th, another person. "The owners, Kyle and Haley, are awesome. You should definitely give it a shot." Keep going down through social media. Again, and I'm not positive, but I'm sure one of these is a relative. "I wish you guys much luck, success on your new business venture. No doubt you and Kyle will rock it." That's awesome. More and more, several more in there on the Facebook. But the most interesting thing, and I'm not a big Facebook person. My kids created my Facebook for me. But Miss Haley Hunt has 2,462 followers. Mr. Lynch or Mr. Olson is not one of them. I find it very strange for you to own a business and you don't even follow your own business Facebook. Mr. Kyle has 465 followers and members. Mr. Lynch and Mr. Olson is another one of them. So I just find that very, very strange. I sent out 4 secret shoppers. You can believe it if you want to or not. Kyle told all 4 of them he was the owner of the business. They both have frequent establishments downtown, which I could get sworn statements if you like, as the owners. They introduced themselves as the owners of the Nashville Bar Bike. I'm going to use a word, and I'm not very good at it, bamboozled. I believe that between Mr. Olson and Mr. Lynch and Miss Haley and Mr. Kyle, I can't put my finger on it. But this paperwork and the state paperwork and all this stuff, it just doesn't add up. And I dug a little deeper, and Mr. Olson, in August of 2017 on the LLC filing, he went from active to inactive. The lawyer provided me with all the LLCs and all the paperwork, and if you go in there and look at them, I think you guys probably received a copy, is they changed their names, they changed the address, but if you dig down, look at the you really track it and follow the dates and everything, they did not live in the state of Tennessee at this time when they performed all this stuff. I honestly think that, obviously, Mr. Lynch is the owner. He's holding the golden ticket. And I believe that Haley Hunt and Kyle Thompson is utilizing the permits that you guys issued, which is another violation in the regulation. One other note, too, and for their reference also, they need to go file a business tax license because they don't have one on the filing. That's about it. I believe they have misrepresented themselves, and I believe they have not been very honest, and I believe that, like I said, they're holding a golden ticket and they're running a show. That'd be all, sir, unless you have a question for me.
That's all.
Thank you.
Thank you.
Good afternoon, Mr. Chair. Good afternoon, Commissioners. My name is Boz Haynes. I represent Nashville Pedicab LLC, DBA Nashville Bar Bike. And I did provide a packet of materials that, in chronological order, pretty much tell the story of how we got here today. I want to take the complaints in order. But first, I want to say that, of course, hindsight is 20/20, and while we don't think the complaints are actionable, with regard to the proposal that was made in August and the permitting process that occurred afterwards, which ultimately brought us here with this complaint, there were some things that we could have done differently in terms of timing of disclosures and consultation with the board. But there were no false statements or misrepresentations made at any point in this process. And under subsection 090 of the ordinance, that is the limited issue that we're dealing with substantively, which is whether a false statement or misrepresentation was made in obtaining these permits or otherwise in the permit process. And so I want to walk through these complaints that Ms. Pizzatola has filed against Nashville Bar Bike. Now, they basically allege, one, that we lied to the board about the type of pedal carriages that we saw permits for in 2019. Number two, that we lied about the actual ownership of the company, Nashville Pedicab. And three, the third complaint is somewhat related to the first one, but is a little hard to make out, that the permits were transferred away from an owner of the company to another party. But at the end of the day, we've kept our word on our proposal. The carriages, sure, are different from the ones that we proposed. but the city still has the benefit of the bargain that was made in August of 2018. And more importantly, we never made any false statements or misrepresentations. Now, the first complaint is easily dealt with. Mr. Lynch, who's sitting here, and will testify to this, is the sole member of Nashville Bar Bike and always has been. If you look at pages 2 through 4 of the documents, the Articles of Organization, the Metro Business License, and the IRS EIN verification letter all list Patrick Lynch as the owner. The annual reports that have been filed since 2013, which are listed on pages 5 through 11, and the Secretary of State info, which I pulled as of this month and is on page 12, show Patrick Lynch as the owner or member of the company. The annual reports only list Haley Hunt as a registered agent. The business is not, quote, registered to her, end quote. She is only an agent for service of process. And so, other than the social media evidence, which was read into the record by Ms. Pizzatola, but not shown to us or to the commissioners, there's no substance to that complaint. The second one is the biggest one, and it is the one that was deliberated on last month. It's true that our prior manager, Dustin, gave the board assurances about the kind of pedal carriages we would use, and we wound up using a different type of pedal carriage. But context is important. Now, the proposal contains the type of bikes, and it begins on page 14, I believe. And we submitted the training documents and photos of the carriages. They're on page 21. And we exchanged emails with the commission about these carriages, and they start at page 37. Now, it's undisputed that at the time we made that proposal to the board, we had actually purchased those bikes and fully intended to use them. So at the time we made that statement, it was true. We did not come to this board prior to purchasing pedal carriages, claiming we were going to buy one type of pedal carriage and then buying another one. But the facts and circumstances changed. We had the carriages shipped to us that we told the board we were buying, imported them from China, but we found them unsuitable for use in Nashville, in the streets of Nashville. The topography, as some of you know who've lived here all your life, the topography is hilly, even in downtown Nashville. And so the bikes were not really, or the pedal carriages weren't really suitable. Now, you can see some of the issues that we were facing. You see the documents on pages 26 through 35. There were issues with bad wells, cracked drum brakes, crooked drivetrain, and some re-welded parts, and there were some tire strength issues as well. In our opinion, we didn't think that they were suitable and could have posed problems, so we determined not to use them. So after that, we tried our level best to find apples-to-apples substitutes for these carriages. You can see that we tried to buy a similar vehicle from Party Bike and or Pedal Crawler, but we couldn't find a suitable apples-to-apples comparison. So we found another type of pedal carriage that seats more people, seats about 12, but it was different from the ones that we had initially planned to use that we had discussed with the board back in October. That's not disputed. But as you can see on page 45, in January, we sent a letter to the commission indicating that we would surrender our 20 pedicab permits in exchange for 2 pedal carriage permits and complete the transition in January, hopefully, and that we would not operate any vehicles until that transition was complete. And we kept up, and we held up to that representation. We did not put any vehicles on the street pending that transmission. Now, you'll see thereafter on page 47, we got a notice saying that our existing permits were set to expire on April 30th, and renewal applications were needed to be in by a date certain. Now, we intended to conduct the permit switch, but we weren't quite sure of the type of application that we were going to need to use, one for new permit or one for renewal. And the text between Ms. Hunt, who is seated 2 rows back, and Mr. Lynch showed that there was some confusion internally as to the type of permit that was used, that they needed to use. So Ms. Hunt went to the commission office and was told that she needed to fill out a renewal application. On page 47, you will see the structure form that we got from the office, and there are handwritten notes from an office staffer that indicate that we needed to fill out a renewal application. So we did that on March 22nd. And in that application, and this is key, we were upfront with the commission about the changes in the type of vehicle that we sought to permit. And we made full and complete disclosures to the commission thereafter as to the insurance, as to the leasing information, as to all the other information that was relevant for the commission to process the application. As you can see on pages 51 to 59, we sent photos of the vehicles, we sent proof of insurance with the vehicle identification numbers, and Mr. Lynch had calls with the executive director about the leasing arrangement of the vehicles and the details relating to these vehicles. We sent the lease, and that's on pages 57 to 59. And as you can see in the email on page 61, I believe it's dated March of this year, the commission confirmed that we had sent everything we needed to send to the commission to process the application, which is critical because we did not hide the ball. We provided all the information necessary to show the commission that we had had a change in circumstances, that there was a change in the type of vehicles that we wanted to use. And again, hindsight is 20/20. We could have handled this. We could have handled things differently by addressing the issues with the board directly and consulting with the commission as we were trying to hash these issues out. That was before the company had legal counsel, and it legitimately thought that it was working in good faith under the permit swap arrangement. When the situation changed, we were upfront with the commission on our change of plans. We made no misrepresentation or false statement to the board as defined under 6.75-.090A4. And there have been no other violations alleged or found of the code by my client with regard to the operation of these permits or these pedal carriages in any way. So at the end of the day, what we're dealing with really here is the type of vehicle that the commission has permitted. And I think to put this in context, I would point you to page 1 of the materials. The carriages that we currently have are about 17 feet long and seat about 12, maybe up to 15, but a lot of that extra space in the back of the carriages is used for storage. The carriages we bought but considered not suitable were about 6 feet shorter and sat about 6. But when you look at the context of our proposal, the net effect is the same. We've reduced both our fleet and our total vehicle footage by about 80%. And this board was very adamant, this commission was very adamant both in August and in June that the footprint that is left behind as a result of this arrangement was important. And so the footprint remains the same. Meanwhile, the pedal carriages we're operating are safer and more efficient than the pedal carriages that we'd originally bought. They fit the ordinance's broad definition of broad classifications under the code. They meet the requirements of the code. And the arrangement has had the intended effect that both we and the board anticipated, a net reduction of 18 vehicles off the streets of downtown Nashville. With us meeting the letter and the spirit of the permit swap and putting safer, more efficient pedal carriages on the roads, I would respectfully submit that there is no rational basis for suspending or revoking the licenses under the relevant provision, .090A4, or simply because the vehicles are different from the ones that were initially proposed. It's also worth mentioning that after applying for these permits, we allowed our other 18 permits that we agreed to surrender to lapse. So we no longer have those permits. So if the commission were to take action, it would not only cripple the business, it would set a bad precedent for this board to take adverse actions against licensees based on complaints filed by direct competitors, and ultimately work to stifle good old-fashioned legal competition. So with that, I'd like to call Mr. Lynch up first.
Mr. Haynes, I do have a quick question.
Sure.
Is the company operating one 15-passenger bar bike or two?
So we have two. I mean, we don't really have the demand to run them both, ever. We hope to get to that demand, but no. I think the most bookings we've ever had in one day is 4 or 5. So there's been no demand for us to have the second one used.
All right. Thank you.
Okay. Oh, BJ, if you will say.
Oh, sorry.
Okay.
You guys can call me PJ or Patrick.
Mr. Lynch, why'd you decide to make the switch from pedicabs to pedal carriages to begin with?
The pedicab business, I think I've been working on the pedicab since 2013. We worked with Billy to draft the legislation in 2015. We spoke to the board about it multiple times, and it started off, it was awesome. It was so great. Our first 2 years were fantastic. And then it steadily went down in terms of more increased competition in terms of the golf carts, but then there was a lot more regulation that was happening in terms of we weren't allowed to access CMA Fest, we weren't allowed to access Stanley Cup, we weren't allowed to access Titans games. And then they changed the driver's license requirements, and it just became very difficult for us. And with I don't want to say strangling regulation, but it became very difficult for us to run the business successfully. And we knew from our conversations with Officer Bork and the police that they weren't always happy with us, and they weren't happy with the speed that we were going sometimes. So we pushed these bikes as hard as we could push them in terms of getting better motors and bigger batteries and all these things. And it was just the writing was on the wall that we should transition into something that is more palatable to the city. And I thought that this was the perfect opportunity. Was they don't want, we got the feeling that we weren't wanted, and this would be a really mutually beneficial thing to shrink the footage of how many bikes were operating in the city. So we came up with this proposal, and I thought it was a great proposal.
Okay. So the pedal carriages, the original ones,
Yes.
that Dustin presented in 2018. When did you have them in hand? When did you have them shipped?
We first got those so we ordered them in January, and they got delivered in March 2018. So we got these things knowing full well that you guys could turn us down and that we would have to take them to another city or try it somewhere else. But to us, it was worth the risk because we were really struggling.
Yeah. And so I've already talked about what, the kind of, and the issues with them, and the commissioners have pictures of the issue, of the problem, so.
Do you mind
Go
if I
ahead,
interrupt
go
you?
ahead,
Sorry.
I know.
What you guys have pictures of is only the things that we immediately got right off the bat, and we were like, these are bubblegum welds. These are they were just the things we didn't unwrap these things because we didn't know if we were going to have to resell them or if we were going to operate them, and we didn't. So that's why they sat for so long. So we got approved. We were super pumped. We go, we try out the bikes. They are terrible. This is one of the worst business decisions I've ever made. And I think Miss Pisatola is completely right. You don't have to account for the money that I wasted and all the money that we put into re-welding and getting new parts and trying to make the motors better because the motors that were coming were everything was very frustrating about these bikes. And we worked very hard and spent a lot of money trying to make them work. What it comes down to is if I put that, when you sign the renewal app, you have to say I attest that this bike is in good condition, it's in good working order, and your name is on the hook for that bike. There is no way that I could have known that when I ordered a brand new bike that they would have come with so many issues. So when we first made this proposal, I was 100%. I was oh, we got brand new bikes. When you get something brand new, usually it's pretty good. These were not good. They weren't even bad. They were terrible.
Okay. So then you bought the ones that you have now.
So before we bought the ones that we had now, I went to 6 manufacturers in North America, and we called them all, and we were do you guys do custom bike design? So these bikes were going to be about 11 feet. Mainly, I think the 17-foot pedal taverns have a 12-foot wheelbase. And we were can we make these things 12 feet? And multiple people were no, not willing to change the design for you. No, not worth making it just for 2 bikes. Or it'd be no, we don't think that's going to be safe, and I'm not willing to put my name on it. It was a very frustrating experience to go through this, and I get it. I made a mistake. I'm not denying the fact that I bought bad bikes, and I needed to come up with a solution. But I've worked really hard to try and find a solution that would be equivalent or as close as I could get to what we got.
Now, I think one of the main issues that's come up is the timing of your disclosure to the commission about these different vehicles that you purchased and how it was communicated. So, if you could have done it differently, what would you have done?
There are 2 huge things that I would have done differently. The first one is at the moment I realized that my bikes were not good bikes and terrible bikes. I should have gone to Billy and been Billy, I've gotten myself in over my head. I need to find a solution. I truthfully would think it would be odd to bring it to the committee, but if Billy had been oh, well, we got to bring this back to committee, I 100% would have brought it back to committee. I've been in the transportation industry for a decade in multiple cities. And any time that we had an issue here in Nashville, I wouldn't, with the pedicabs, and we changed something out, or we changed a motor, I'm not bringing that to you guys to be oh, hey guys, I'm having an issue with this 750 volt motor or whatever. It didn't make sense to me. I didn't even comprehend the fact that I could have or should have brought it to you. But I do regret not bringing it to Billy because I love Billy. I think everyone at the MTLC has been great. They're super responsive. Anytime this guy, I email him, he emails me back. But I don't know. It's not like I was purposely dodging him on this. So.
But when you submitted your application, did you submit everything that's in the packet?
Yes.
That's before the board?
You cannot submit anything to them that is not perfect. If you miss one thing, they're throwing it back to you, being like, this is what you missed. You missed it here, 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 and here. And we had like emails going back and forth. We had Haley go, I don't know how many times you went there. And then like me and Billy, we talked on the phone about why, like we had the lease. Like specifically the lease is this 2-page document. The first page shows the pictures, the second
It starts
page.
on page 57, I believe.
And Billy and I talked about the lease. And it was like an easygoing conversation, pretty much every conversation I've ever had with Billy in my entire life. And it was quick and I don't know. That was it.
Did you ever put the carriages and pedicabs on the road together?
No. We shut down our pedicab operation. Like, we got approved, when Dustin spoke, that was on like August 30th. And then we shut down in September to kind of give our drivers like a chance to find other jobs. And then we just sat, not doing anything. Not running pedicabs because we had promised to take them off. And we were just waiting for our application to come through. But I also was in this position where I was like, oh, I got bad bikes that I can't put on the streets, so I need to find another solution.
How many people do you employ at Nashville Pedicab?
2.
Okay. And who are they?
A lovely married couple as of Wednesday? Last Wednesday.
Okay. What happens if you revoke those permits? Or if the permits are revoked?
This is like it's like a really hard thing for me to be in charge of like your managers, and you uproot them and you bring them to a new city and you have them bring their daughters to a new city and you have them get in schools and get settled and know that you made a stupid decision by not telling Billy about one thing that like truthfully I didn't think that I was doing anything wrong. I 100% swear to you that I did not do anything wrong, or I didn't think I was doing anything wrong. And now it could affect them in a very detrimental way.
Did you ever provide any information that was false?
No.
Okay. Are you the sole owner of Nashville Pedicab LLC?
Yeah, but since 2013, I've owned it. And I've always had managers.
Okay. What role did Dustin play?
Dustin was the manager of our pedicab company, and
He was an officer at one time, right?
like a registered agent.
Yes.
Yeah.
Or no, okay. And what is?
But he never had any like ownership percentage.
Okay. The documents list Haley as a registered agent. Is that right? Okay. And she lives here.
Yep.
Okay. Anything else you want to tell the board?
First off, I am truly sorry about the lack of communication. If I had done this over again, like obviously I would not have gone down the same route. And it's like, but we have really great bikes, and they're bikes that I definitely believe in and that we know are good because Miss Pisatola has been running the same brand of bikes, and she hasn't had any issues. Like, we're putting quality bikes out there.
In terms of the first page of the documents we produced, the footprint, could you walk us through that?
So, and that's the other thing. Like, I know that when you say like, oh, 6-seater to 15-seater, it sounds like this massive difference because it's like 6 seats to 15 feet. But this 6-foot bike is still 11 feet. I mean, it's still big, and like the width of it is probably 5 feet, and the width of these new ones are 6 feet. If you're behind a 5-foot vehicle, like if you're behind a Honda CR-V or you're behind a Suburban, it's taking you the same amount of time. And that was like our mindset was like, all right, we have a Ford Bronco and we're going to a Suburban, I don't know.
Okay. In terms of just driving, the issue, I know you've reduced the footprint by about 18 vehicles, or about 80%.
Yes.
So in terms of just driving, what's the biggest issue in terms of footprint? Is it the length of the vehicle, the width of the vehicle,
I would say
the number of seats?
Without a doubt, the number of seats doesn't matter. Like it's the footprint of the vehicle. If the vehicle had one seat and it was 17 feet long, I don't think that you guys would approve that. But it's the length and the width of the vehicle, and these are comparable. Like it's a 5-foot width versus 6-foot width, and I think the width is almost more important than the length. It's just
Okay. Anything else?
I just want to address like this the stuff on social media from Kyle and Haley. Like, I love those guys, and if they're on a bike and they're telling someone like, "Oh, I own the business," like I'm working hard, I'm okay with that. Like, they're hustling, they're working really hard. Like, it doesn't mean that they actually own the business. And if I need to produce the checks to show that I'm paying them and have been paying them, I can do that. Like, I'm open to it. Like, I'm open to helping you guys out or answering any questions that you have. We really weren't trying to hide anything from y'all or Billy.
Well, let's call up Haley next. Haley, you've already been sworn. Tell us what you do with the Nashville Bar Bike.
I just manage the business.
Okay.
Sorry.
Okay.
I manage the business
Okay.
with my husband.
As part of that, does part of that involve preparing the applications?
Yes.
Okay.
We, the two of us, do everything. That means anything from paperwork and permitting to actual working on the bike. We're the only two people that do everything that the bike needs to be permitted.
Now, you helped prepare the renewal application.
I did.
Okay. Walk us through that process of how Nashville Bar Bike decided to submit a renewal application instead of a new application.
So we were wondering which application was the correct application to get the permit. And those ladies in the office, they are amazing. They are on their jobs. I felt bad for them having to deal with me going in so many times a week and sometimes a day. But we together figured out what we needed for us to be permitted. We both believed that the renewal application was the one I needed to fill out. We were both very much believing in that. I don't think either of us were deceiving. I don't think she was deceiving me as far as which permit. I think she honestly believed that the renewal application was what I needed to fill out for our permit.
Now, on page 48 of the materials we submitted, do you recognize those?
Yes.
Okay. What are they?
They're text messages between me and Rob.
Okay. And so, what are you talking about generally here?
We're just trying to figure out because I wasn't even aware that there were two different types of applications. And I thought because we were a company staying the same name but just changing our business, and this is my first time dealing a lot with this type of information and procedures, but I was under the impression that to go in and say, so is the renewal application the one I'm supposed to fill out? Like, is this the right, am I going in the right direction? And I, obviously was seeking help from them because I had no idea where to start. So that was pretty much us talking to each other, trying to figure out if we were headed on the right direction.
What about the next page, page 49?
So this was actually one of the few times I went in. Miss Millie in office, she was telling me, so we agreed that the renewal application was what I was supposed to fill out. So she put an arrow to it because she gave me a bunch of information. So she gave me a few sheets. And this is pretty much like, okay, so in order for you guys to get permitted, this is what I need you to do. I also have the fees that I'm going to need you to pay for the renewal of the application.
And so based on what you heard, you picked up the renewal application, filled it out?
Yes.
Okay.
Mhm. And she also was sent to us as well. She had called me and told me that a packet would be sent to us. I'm guessing for larger scale companies, when that permit is expired, they send out, because all the permitted drivers also have to get new permits. So we got the renewal application as well as maybe 5 to 6 driver applications as well as company affiliate sheets. So we both all felt like we're on the right path, especially since it was sent to us.
Do you have any ownership interest in Nashville Pedicab, DBA Nashville Bar Bike?
No.
Okay, thanks.
Mm-hmm.
I have one more thing.
Okay.
We do have our business tax license paid. I just got a picture of it. And I also do actually own property here. So that's another
Okay.
thing I do.
Okay.
Property.
With that, I'll be happy to take any other questions.
What is the length difference between the 6-seater and the 15-seater?
I believe it's about 6 feet.
Thank you.
Okay. Thank you for the opportunity, for letting us present our case.
Ms. Pizzatola, do you have any rebuttal that you'd like to offer before we start deliberating?
I would. I'll be short and sweet. I lost her on all the permit information stuff that has nothing to do with this. It's irrelevant. Bottom line, like I stated earlier, you approved two six-passenger pedal carriages, and that's what should be operating. The length of the bike was very specific on August 24, 2018, when Mr. Olson stepped out on the floor in front of you and gave you a description of the length of these bikes, which I think helped make your decision in the footprint of removing the pedicabs to these two six-passenger pedal carriages. And just real roughly, I just want them to know that I rode your pedicabs many times from the CMA Fest Titans football games in the last few years. So I'm not buying that the business wasn't there. But regardless, I just hope you make the right decision. I mean, I know that if this was me, I would have been off the street immediately. I'd have been fined. A few years ago when I brought out a second bike with a motor and you shut me down for 2 weeks. It cost me about $10,000 in sales because I made a stupid decision. And he stood up here and said he made dumb choices, bad decisions, bad business decisions, failed to, do the right things. And I feel like you have to pay for your choices and your decisions. That's all.
Thank you. Mr. Fields, could you, or Ms. Costonis, read to us the section 6.75.090?
Sure. So in the three different complaints, there are three different sections cited, and that is the one that is cited in the first complaint about, it says basically 090A, a certificate issued under the provisions of this chapter may be revoked, suspended, placed on probation, otherwise restricted, or not renewed by the MTLC if the holder thereof has, and then 4 says, made a misrepresentation or false statement when obtaining a certificate or additional permits or transferring a certificate. Do you want me to read the other two sections she cited as well?
I will. I figured we'd try to take them one at a time, but and the other two is 020C and 040C4.
Correct.
Ms. Costonis, would you mind if I was able to see it in black and white? Thank you.
Oh, okay. Okay, I got it.
You got it?
Yeah, thank you.
You know, is there a mechanism for the commission to recognize a mistake has been made in the issuance of a permit and to correct the mistake? Or once a permit's been issued, it can't be undone until the year's up. How does that work?
I'm not sure this is what you mean, but maybe placement on probation?
No, my question is that I don't think anyone's disputing that we issued 2 permits to Nashville Pedicab doing business as Nashville Bar Bike for 2 6-passenger pedicabs, correct? and that when it came time for renewal, the company submitted their paperwork. It was clear from the paperwork submission that they were renewing 2 pedicabs, but they were going to be 15 passenger cabs, and they got renewed. And if the intent was that they only had 2 6-passenger vehicles, my question is there a mechanism for the commission to be able to undo the issuance of 2 permits without necessarily a finding that there was a misrepresentation or false statement?
Oh, would there be another basis for a revocation of the
Yes.
permits? I mean, the other section, one of the other sections she cited, 040C4, is about the eligibility for an applicant to be considered for the grant of a certificate. And it does say that if they would be ineligible if any portion of the application is incomplete or contains incorrect or untruthful information. So, I mean, this information was incorrect, if not untruthful. But I don't think that helps because at this point in time, it's already been issued. You know, it's not.
Right. That's my question. Is there a mechanism?
There is a precedence. I'm not sure there's a mechanism. Several years ago, and frankly, I don't think it's possible for me to draw from my memory or even from the records. A permit was inadvertently issued to a vehicle that should not have had. This is historically, we had a vehicle that we issued a permit to that we did not have the authority to issue. I was advised at the time that what should I do, and I was advised to have the permit returned to the commission because I was told at the time I didn't have the authority to do more than the commission advised me to do. In this particular case, I'm going to take absolute full credit for the issue of the permit because I have to do that. But frankly, I can tell you I didn't see the picture. And had PJ come in, he described me pretty well. We would have had a conversation, and what I would have said was, I get what you're saying, I understand it. However, I don't have the authority to issue a permit for this vehicle. I can issue a permit for this vehicle. In other words, when you tell me to issue a specific permit for a specific vehicle or kind of vehicle, if you tell me to issue taxi cab permits, I can only issue a cab permit. It has to meet the definition of a cab. In this case, you had a definition and a description given to you during the process. So, again, I stand by that it was issued, but it would not have been issued had I actually saw the photograph. We, in no time, talked about it going from a 6-person to a 12-person that I recall. There's nothing in the insurance document or the leasing document that I can find that talks about it. Now, I also understand the situation. I'm not challenging the rest of that. I'm just saying I can't issue what you can't tell me to issue, and that was my error.
Yes.
I'd like to make a motion we revoke both licenses because he is not operating the vehicles that were approved by the commission. That's what I heard.
Is there a second?
One question here. Do we have a section or subsection? Do we have the ability just to simply revoke it without stepping on the toes, so to speak, of the issuance of the license?
So ODOT lists the bases for revocation, and it's like C is not the only basis for revocation, but there are some other bases. I don't know if any of them would be applicable here. If the holder of the certificate has violated any of the provisions of this chapter or failed to comply with any rule or regulation established by the MTLC, if they violated any provision of this code or other ordinances of the metropolitan government or laws of the United States or state of Tennessee, the violation of which reflects unfavorably on the fitness of the holder to offer transportation services, if they failed to pay assessments or taxes due to the metropolitan government, and then the one that we've been talking about, that they made a misrepresentation or false statement when obtaining a certificate or additional permits or transferring a certificate. So,
And I think,
Yeah, and as Mr. Fields just pointed out, Ms. Costonis, there's been a precedent where he was told by the commission, you issued a permit without authority, you need to go get it back. And that's what it looks like has happened here, is two renewal permits were issued earlier this year, and when they shouldn't have been. And
For those
there
site
doesn't have to be a finding that there was because I don't see it. I agree with Mr. Haynes that there wasn't a misrepresentation or false statement made during the application. It was not caught by the office when the renewal process was going on.
Mr. Chairman, if I may be heard.
Sure, yes.
Okay. I believe that based on what we've heard from the executive director, to his credit, he's been credible. This issue was a matter of a mistake on his part, not a false statement or misrepresentation on my client's part. And under .090, none of the other grounds apply for suspension or revocation of a license. And with regard to the precedent, I think that without knowing the specific licensee, without knowing, the factual circumstances, I don't think that that precedent affords the commission a sufficient basis to, lawfully proceed based on that precedent.
Well, as it stands, though, right now, Mr. Haynes, Nashville Bar Bike has permits to operate 2 6-passenger vehicles.
Actually, as it stands, the proposal was to operate 2 6-passenger vehicles. And we were up front in the permitting process for two 12-seat vehicles, and we received permits for those vehicles.
Without the authority of the commission, Billy did not have the authority to issue 2 12-foot permits. He only had the authority from the commission to issue 2 6-foot. So that those permits need to be reclaimed because there was no authority given to issue them.
Mr. Fields, and respectfully, Mr. Fields has not been able to cite the specific precedent. And the fact that that precedent occurred does not necessarily make it lawful.
Well, the board only agreed, precedent being out of hand, the board agreed to only issue 2 6-foot permits. Precedent or not, it was an agreement upon the surrender to issue 2 6-passenger permits. So even without the precedent, it is, if you want to take that away from it, then it was a misrepresentation because the client knew what the agreement was before going to the office to ask for the permits. At no point did they come back before the commission and ask for a deviation in what they were requiring. I understand being a business owner myself and operating trucks, having to augment them and sometimes totally having to scrap those trucks because they do not meet DOT regulations. It can be a costly mistake. However, it is not impossible to get 2 6-foot pedal taverns built. It might be a little more digging and in-depth probe on your end to even maybe have one manufactured out of a mold that has not been yet done, but the fact still remains an agreement was made by not by yourself, by a representation of your company as a manager, someone in charge to make that deal. that those trucks would be, or taverns would be 6-passenger, and the length would be shorter. Not putting 6 seats on a 15-passenger, but the length would be shorter, the bikes would be totally different than the footprint that we have. That was the agreement.
2 points I make, Commissioner. Number one, with regard to misrepresentation, you have to look at the representation at the time it was made. The proposal that was made in August of 2018 was for the carriages that you mentioned. At that time, those carriages were in hand. And so at that time, that representation was true. And we made true and complete disclosures with regard to the carriages that we sought permits for in March of 2019. I'm just talking about the limited issue with regard to representation or false statement. Just as a matter of construction, I don't believe that that fits here, as the chairman has pointed out. Now, the basis for this hearing was on whether a false statement or representation was made, whether we had made a false statement or representation. If the board is determining to revoke if the motion on the table is to revoke the licenses on an alternate ground, then I would request additional time to provide a legal statement on this issue. Otherwise, there are going to be some process issues with the revocation decision, and none of us want that.
Suggestion just in terms of procedure. If the commission is going to rely on Mr. Fields' testimony about what happened, I feel like he should be sworn as well. I don't believe he was sworn when the witnesses were originally sworn.
Okay.
I have another thought too, but again, this is outside the complaint of
Yeah,
Mrs.
and I do too. And I wanted to make sure we're all talking about these issues, because I don't see that Mr. Lynch made a misrepresentation. What I see here is a mistake by our office, and had the mistake not been made, it would have been realized at the time during the renewal that the permits should not have been renewed, because these were not the pedicabs that we believed were going to be issued by Nashville Bar Bike. And
I think you're not saying so much that you want to revoke it as that it was originally issued in error?
correct, the renewals were issued in error. I'm calling them renewals because apparently that's what everyone's been calling them. Maybe they were original issued permits.
I probably would have said fill out the application as a renewal, since the commission established that new certificate at the August meeting, even though the bikes had not gone into service yet. We don't have to inspect the pedal carriages or the pedicabs. We're reliant on the owner of the vehicle to say that they're all in good order, and that's what the ordinance calls for. What happened then and what didn't happen then is a more complete and comprehensive review of every application that comes through. And for that, again, I apologize to not only to the commission, but I apologize to Mr. Lynch. By the same token, I think you're in a place where there was renewed because it was my impression they were the same vehicles that were approved at the meeting in August. Same kind. I should have compared, like I do taxi cabs. I look at the VINs, I look at the certificates, we look at everything top and bottom. We do that with the carriages. We're not required to do that for the pedal vehicles or the low-speed vehicles. It may be that needs to be added as a departmental policy.
And I have one other thought as well.
No, I just have a question. So when these permits are issued, do they say permit for 6-seat or permit for 12-seat? Like, what does it say on there?
Typically, what we're going to do is give them a decal, and that decal is going to be a decal with the commission's name and a number. What that's going to then correspond to is what was given to us in the application that says it was this vehicle, and in this case, one of two vehicles. So it's a little different when you got 400 or 500 taxi cabs, but clearly they should have been assigned to the original vehicles. But since we don't have to apply the decal, as we do on taxi cabs, we don't physically see the vehicle.
So yes, that's part of what I was going to point out also. So like, as with most of the different classifications of vehicles for hire that you all regulate, there are kind of multiple layers of like permits. There's the certificate for the company itself, the certificate of public convenience and necessity. There's a driver permit, and then there's usually a specific vehicle permit as well. And so it's the vehicle permit requirement provision that I also wanted to read to you. Although, again, as back to the point that Mr. Haynes made, this is outside of the scope of Ms. Piscatola's complaint. But it says, each pedal carriage and pedicab must have a permit issued by the MTLC. The permit will identify each pedal carriage and pedicab by a unique number in accordance with the rules and procedures established by the MTLC and will be associated with a specific classification and by certificate holder. Permits are not transferable to other pedal carriages, pedicabs, or other certificate holders.
Right, and
that's section 290.
I don't think there's anything prohibiting the commission from addressing an issue that it sees in a complaint sua sponte, which is what I'm seeing here, which is they got 2 permits for specific types of pedicabs. When it came time to actually get the certificates, they submitted all the paperwork. They were not the exact same permits, and so I think there is a mechanism that we can apply to say, yeah, these permits were issued by mistake. Now, it may be that it makes sense for us to be considering whether or not we should issue them a different permit. I know when we met last year, we specifically granted Mr. Olson's company 2 permits for 6-passenger pedicabs, and now they're operating 1. They have 2 permits, but they're operating 1 on a regular basis. I guess they're changing them out from time to time. So, from a common sense standpoint, it would seem to me that we could issue the company 1 permit, which recognizes the mistake that was made and addresses it, but at the same time, I think gets us near the same result, which is what Mr. Olson's point that he was making last year when he came to us and says, look, we want to change our business model. We don't want to operate individual pedicabs anymore. We want to turn those in, and we want to start operating larger multi-passenger pedicabs. We plan to operate 6-passenger pedicabs. We bought 5. We would like as many permits as you're willing to give us, and we gave them 2.
So, I think the question is what action we're taking here. I was going to read the due process provision relating to the disciplinary action, which is kind of, I believe, I'm not looking at the agenda, but this was noticed basically as disciplinary action. And so under 575-090B, it says prior to any action to revoke, suspend, place on probation, otherwise restrict, or not renew a certificate, the holder shall be given notice to the address listed on their certificate of the proposed action to be taken, and shall have an opportunity to be heard by the MTLC. So if our, and Mr. Fields is handing me a copy of the notice letter that was sent to Mr. Lynch, advising him to appear actually at the June meeting, because this is kind of a continued adjourned hearing. And it references the complaints of Ms. Piscatola. that is what he was noticed to be here to defend today. So if the action that is being taken is, I think, different from what that notice contemplated, then I do think from kind of a due process perspective, it would be more appeal-proof for you all to go ahead and give him the opportunity he's requested to prepare to defend the alternate process.
And if I may, Mr. Chair, we are not questioning the commission's authority to do what is being proposed. Our issue is notice. And I think Ms. Costonis has laid out very ably what the notice issues would be if action were taken outside of the scope of the complaint or complaints before the board. Now, that being said, I've just talked with Mr. Lynch. We're willing to discuss during that notice period some type of resolution that would give the commission and Nashville Bar Bike the benefit of their respective bargain back in August, understanding that there were mistakes and communication breakdowns, in the intervening 11 months. So I just put that before the commission for its consideration.
Thank you, Mr. Haynes.
Mr. Chairman, if I may. I think there are several things that you can do, and you've heard me speak about this, whether it's today or with notice in the future, in terms of, because you certainly don't own a certificate, but you certainly control and determine where certificates are. I think in a situation like this, one of the things I think there's some other options that you can take along the way that are not necessarily revocation, not necessarily even suspension, or by looking at what your intent was. And at the August meeting, you're going to be considering any applications for any new vehicles. That's not a part of this because they've not made application for it, but that's a thing that you're looking at, and that's what you went through last August, is trying to determine what do we need. And that particular day, you had determined that it was better to have fewer vehicles than it was to have more vehicles, so we'll swap 20 of one for 2 of the other. There is no doubt, and I'm not defending because I don't. I can only defend myself, and I'm not even defensible at this moment. But from the standpoint of what's out there, I think there are a couple of things you could do. You could say, look, if you want to, we approve 2 6s, go get your 2 6s and come back. 2 6s equal 12. We're going to take 1 away, and you can have a 12. I think there's lots of things that might want to be out on the table that's now again, I think it becomes a policy issue that the commission has to make a determination on. And that's not something that I can do. And clearly the approval and the request was given to you, not to me as a director. So you were the ones that he spoke to and made whatever representations they made last August.
This question is to legal. If we were to, do we have the ability to take back one of the permits without taking back both and requesting a refiling of a new application altogether? Do we? Or would that have to be voluntarily surrendered?
So it's a little more complicated than that, because what he got was a certificate of public convenience and necessity to operate a company, and one of the kind of conditions predicate of the issuance of that certificate was that it would encompass 2 bikes. So, well, actually, it's actually even more complicated than that, because he originally had a certificate of public convenience and necessity to operate the pedicabs when he had the 20 pedicab permits as well. So then the permits are the individual ones that go to the number of vehicles, like the per vehicle permits. So there were 2 per vehicle permits. Now, the per vehicle permitting is usually not done at the commission level. It's done administratively. But what staff would be checking for with the permits is that if you have a certificate that limits you to 2 permits, that you have, in fact, 2 vehicles that you use. And that those vehicles are the permitted vehicles, the unique identifier that was referenced in Section 290. So that, I think that is, it's harder to split it up because the revocation provision is for revoking his certificate to operate a pedicab or pedal carriage company altogether. And it sounds like that's not what you have in mind. You just want to take one of the vehicle permits away, if I'm understanding correctly.
Correct.
I mean, certainly I do think that if we were to come back, I don't know if you could do this with a motion today, or they would prefer to come back and have another opportunity to be heard. But certainly, if Mr. Lynch were to be willing to say, for example, surrender one of the vehicle permits and have the certificate reflect in future that he would just have a permit for one 12-seater vehicle, something like that maybe could be worked out by agreement.
We would be open to that. My client has offered to voluntarily shelve one of his permitted vehicles, pending either discussions or the setting of another hearing as a show of good faith. Whether it's through the commission office itself or Metro Legal, we're happy to explore some alternatives to resolve this because, again, we know we made some mistakes.
Well, I think that's a good idea, Mr.
May I
Haynes,
approach, please?
to come back. And Ms. Pizzatola, you can talk in just a moment. Because I want to make sure we're handling this the right way, obviously. And it seems to me that when the permits were issued by our office, they would not have been issued had we known that they were operating 2 15-passenger vehicles instead of 2 6-passenger vehicles. And I do think we need to figure out from Metro Legal, what kind of authority do we have to correct a mistake. And I would think that there's got to be some mechanism within our rules that allows us to do that.
I mean, what I would go back to would be 020, was it C4, which basically says that you're ineligible for a certificate if part of the application is incorrect, because then you don't have to make a finding of misrepresentation. There's just an inaccuracy,
Right.
Which is, it sounds like, is kind of the fact-finding direction that the commission is going in. Basically, I think you're saying that maybe the certificate was kind of, not to be too legalese, but void ab initio or something like that, because it was based on a false presumption that these bikes were a certain type of bike when they were actually another type of bike. And I guess, you could make a fact-finding to that effect, but that would have the consequence of basically revoking his certificate to operate altogether, which may be a more severe consequence than you're actually contemplating as fair from some of the other discussion.
Well, that's why I would want to know, do we have a mechanism to then issue one permit, for example?
Yes. I mean, I think it wasn't on the agenda today, but so that the question might be noted.
This is just discussion, because I know this is not happening today.
Although this is actually This is a regularly scheduled meeting, so you have a little bit less stringent notice requirements for your agenda applicable than you do in a specially called meeting. But yes, I mean, well, I think it's probably a fortunate coincidence that next month is August, and that's when the usual annual meeting for issuance of new certificates and new permits is held anyway. But certainly at the August meeting, you could issue a new, perhaps replacement certificate to the company Nashville Party Bike, is it?
Yes.
Bar Bike?
Nashville,
Bar Bike,
and,
sorry.
DBA Nashville Bar Bike.
Okay.
We're also willing to explore ways where we can try to modify the vehicles to get them within that footage requirement that was discussed back in August. That would require the reduction of some seats as well, and may get us to 6 seats. We're willing to consider that, but again, I'd like to be able to have some time to address these new issues and discuss potential solution in the interim.
Okay, well, let's put that on the agenda for next month. Getting back to Ms. Pizzatola's complaint, Ms. Pizzatola, you wanted to add something?
I do, sir. If you remember, and I want to refresh your memory, October 2018 is when they sent the emails requesting to purchase a bike. A 15-passenger, for the record, they're not 12 passengers, it's a 15-passenger, the back bench seats 3 people, it's not storage. Since October 2018, he had over 6-7 months to notify Mr. Fields, I'm going to have to make a change. They never did. They wouldn't be here today if it wasn't for myself and the other competitors who reached out to me and informed me he was operating a 15-passenger bike. He would still be out there operating that bike. He had no intentions, never any intention to let you know or Mr. Fields' office know. He should have let Mr. Fields' office know and been up and honest the day he dropped off that form. And he was not. And I'm going to back up to his pedicabs one more time. He did not remove 20 pedicabs from a footprint off the city or the streets of Nashville. He never had 20 employees. Never at one time was there ever 20 pedicabs operating on these streets of Nashville at any given time. That was his pitch and his selling point that got him to 2 6-passenger pedal carriages. If he wants to surrender, that's fine, but he needs to still meet the 6-passenger pedal carriage that he was approved for. And I'm more than willing. I know somebody that can build him one. I'm more than willing to assist him with that. And the footprint of 2 6-pedal carriages, passengers, is a lot bigger than one 15-seater. You're looking at about 23 feet versus 17 feet. And then you're looking at 2 vehicles versus 1 vehicle, interchanging traffic downtown. Trying to find a place to park. It's a big difference. I just want to let you guys know that, and thank you.
I think we've heard enough. Thank you. All right. So getting back to the actual complaint at hand, Commissioners, Ms. Pizzatola has brought a claim that Nashville Bar Bike violated Section 6.75.090, which states that a certificate issued under the provisions of this chapter may be revoked, suspended, placed on probation, otherwise restricted, or not renewed by the MTLC if the holder therefore has, and I'm citing the section that Ms. Pizzatola relies upon, made a misrepresentation or a false statement when obtaining a certificate or additional permits or transferring a certificate. I did not find, based on the testimony we heard, that there was an actual misrepresentation or false statement made by Nashville Pedicab doing business as Nashville Bar Bike. So I would I would think we would not find that there was a violation of 6.75090.
I agree with that. It's pretty clear to me that he made a statement intending to do one thing, ended up doing another thing for whatever reasons. If there's a failure, it's a failure in coming back and saying, hey, wait a minute, which it sounds like you should have done and probably knew you should have done. And I wasn't here in August of 18, but if there was all this discussion about we're reducing the footprint and it's going to be 6, then the knowledge that it's going to be 6 was there. So, but I don't think it fits this section.
Can I ask a question? If I understand it right, tell me if I'm wrong. He is not operating the vehicles that you approved at that meeting, is that correct?
That I approve.
Oh, the commission approved, I'm sorry. No, the commission, for the initial application.
We have, historically, the commission has not required the permits of, for instance, vehicles like this. When people are making applications, we have not made them produce the vehicle to actually look at.
Right.
So we did not see, he said 2 6-passenger.
And that's what was, that was what it was approved.
That
Correct.
was not a part, it was, that was the discussion that afternoon, yes, that was a part of it.
So he's not operating vehicles that were approved.
Correct.
Okay. So he's been operating illegally. Period. All this other doesn't really matter.
Well,
I mean, it does matter, but
And I think that's what I was getting at earlier, which is I don't think that Nashville Bar Bike is operating the carriages that we believed as a commission that we were going to be approving for, with 2 permits. But in addressing Ms. Pizzatola's complaint, I'm not seeing that they made a misrepresentation or false statement. What I'm seeing is that our commission issued these permits in error earlier this year. And in order to remedy that error, we need to give some notice to Nashville Bar Bike, which I think we're doing and putting on the agenda for next month, to say, you got to come back because I think we're considering revoking your permits because they were issued in error, not because they made a false statement or misrepresentation.
okay. But if they were made in error, do they actually have legal approval to operate? The vehicles they're operating now.
I mean, so, I think the issue is more the vehicle permits and rather than the certificate. I think we've sort of established that you all feel that the application for the certificate did not make a false statement or misrepresentation. So that is not a basis for its revocation. But there is another provision of 090 that says you must comply with all provisions of this chapter 675. And then there's the provision 290 that says each vehicle must have a permit and those permits are not transferable. So I suppose you could say that if you found 290 was violated, then you could find another subsection of 090 violated. But that is not, again, that is outside of the scope of Ms. Pizzatola's complaint. She did not make that argument, and he was not given notice of that argument.
So the argument is placed before us, we are finding no misrepresentation. Even though there might be precedents for one, it has not been presented to us to investigate.
No, what I'm suggesting is that Ms. Pizzatola's complaint for a violation of 6.75090 fails, but in the midst of us addressing the complaint, it appears to me that the 2 permits that were issued in error, and we need to have them come back before us next month so we can decide what we're going to do about it.
And next month's meeting is when?
August 22.
August in just the August meeting?
It's the regular August meeting.
I make a motion that this be tabled to the August meeting to give Mr. Lynch.
If I could, I don't mean to interrupt, but I think that we do need to address Ms. Pizzatola's complaint. So I would like
Okay.
to make a motion as to whether it's dismissed or not. And now we have to also address her other two complaints, but let's
Do them one at a time?
let's do it one at a time.
Okay, so the one we are dealing with now is complaint.
It's the original complaint for violation of 6.75.090.
This one.
090A4.
Yes.
175A4. $6.790A4.
090A4.
So I'll go ahead and
False
make a motion to dismiss the complaint under 6750904.
Which was for false representation.
Right, misrepresentation
second
or
that
false
motion.
statement.
All those in favor?
Aye.
Any nays? Motion passes. I do think we do need to make a motion to put on the agenda for next month. Consideration of whether to revoke the permits due to them being issued in error.
Do you
I-
want to address these two? and then-
We'll look at them next.
Okay, again, I'd like to start my motion to put on the agenda for the next meeting, Mr. Lynch's ability to, are we doing his ability to keep the two permits?
It's to address the issuance and to consider whether the issuance of the permits to Nashville Bar Bank were in error.
I'd like to table it to the next meeting to address the issue of if the permits were issued in error to Mr. Lynch.
Second.
All those in favor?
Aye.
Any nays? Kira, are you abstaining or are you?
Do I
actually
need to
voting?
say I'm abstaining? Yes, I'm
Just to
abstaining.
be
yes.
clear.
Oh, I'm sorry. I apologize. I was just staying quiet.
All right, motion passes. Now we have the other two complaints by Ms. Pizzatola for violation of 6.75.020C and 6.75.040C4. If I understand correctly, the gist of the complaints were that that Mr. Lynch sold or transferred the company to Ms. Hunt.
Do we have any legal documentation registered with the state or business office showing Ms. Hunt as the owner of the company?
No, the documents presented by Nashville Bar Bike show Mr. Lynch has been consistently the owner of the company. It does show that Ms. Hunt is a registered agent, but that doesn't mean she's an owner.
I make a motion to dismiss for lack of proof that the company was transferred or sold or given to someone other than Mr. Lynch.
Second.
All those in favor?
Aye.
Motion passes. Is that, just to clarify your motion, Mr. Carr, are you making a motion to dismiss those two complaints?
Yes, I am making a motion to dismiss.
Do we have a second on that motion?
Yes.
All those in favor?
Aye.
Aye.
Motion passes.
Communications through the commission go to Mr. Fields and/or Ms. Costonis?
Yes.
Okay, just want to be clear. Thank you all.
Thank you all, and thank you, Ms. Pizzatola, for bringing this to our attention.
Thank you.
Next, we've got some items under Wreckers. We have a request by Carter's Wrecker Service to transfer a license to Dad's Towing Service for emergency wrecker zone currently operated by Carter's. Mr. Fields?
Anytime there's a change or a requested change for a transfer or modification of a zone, first of all, there has to be a public hearing, but specifically in your rules, it requires that there be a notice given at one meeting and then action be considered at the next meeting. We've had a request from Ms. Carter, who is, she and her family have operated the Carter Wrecker Zone, which is the northwest corner of the county. She has asked that it be, that she be relieved of it. She's requested, she intends to sell the business to Dad's Towing. Dad's at the same time is making application to operate the zone currently operated by Carter. So that has to be it has to be presented to you. No action is required. Both parties are here if you'd like to speak with them. But Ms. Carter intends, for business purposes and other reasons, to leave the business. There will also be a need for you to temporarily assign the zone until, if she's not able to operate it, until a decision is made at the next meeting. I think it's my impression that I think I have the authority because from an emergency standpoint, I think I could probably do it. But I think by noticing the commission allowing you to do that, you have two operators on each side that are regular. On the east, Dad's currently, their zone joins it from the county line all the way down, gosh, I guess to Goodlettsville, in that vicinity. At the south is the Tow Pro zone. Currently, I mean, again, depending on what your desire is, both Dad's representative is here. You certainly could assign to him but you can assign to anybody you want to on a temporary basis.
What is the intention that it be sold to that particular?
She's going to. She doesn't have she can't sell the zone operation. She can sell her business. Her intent is to sell the business to Dad's. Historically, what you've done, in fact, you did it last year. One company sold to another company. They asked for a transfer, and you basically approved this. You didn't have to approve the sale, but you approved the transfer to the person they were selling to. Does that make sense?
Can I say what I think? Okay. There is a provision about a transfer of a license, and this is not a certificate to operate a company altogether, just to have a tow truck company. But this is a special kind of license that is to enable people to provide emergency services, which we have additional requirements before we allow a company to have a license to perform those emergency services, because we need to make sure that they meet requirements such as that they have two trucks available 24/7, 365, that they have a call center, so holidays, nights, weekends, they can be reached and would be available for police calls, and Also, that they have the proper insurance for all of this and a few other requirements of the like. So DADS already has a license to perform emergency services. So that they have met all of those criteria, I think, has already been established. So I think this really is a transfer of a zone assignment. So the zone assignments, it says, the commission shall require all licensees, oops, sorry, wrong section. The commission shall, on its own motion or on the petition of the chief of police or of the metropolitan government or any licensee, may change the established emergency rec or service zones or the licensees assigned to such zones. So I think that's what you're being petitioned to do. When you do that, you have to have a public hearing, and it has to be noticed in advance. And other licensees can have the option of petitioning to be the recipients of that zone reassignment also. So 680, 545 is part of it, and I think there's something in the prior section as well.
Mr. Chairman, Mr. Mitchell is present. He's the operator of DADS and West Nashville.
How you doing, Mr. Mitchell?
Good, sir. I'd like to thank the commission for all their patience and all y'all's great judgment on helping us make all these decisions. I don't know where you find all the patience. And Billy, I promise not to embarrass you.
These people Again, I don't think any action is really required other than today, other than making to allow an assignment. I know you've been what's been your role with Carter's over the last few months in terms of backup? And
We have been backing up Carter's for a while when they need us to back them up. Ms. Carter and I have come into agreement on the purchase of Carter's record service. And, of course, what we're requesting is the zone to be transferred.
Needing to approve that.
right. So,
If no action is required of us, what do you want to say?
I think if you approve the temporary the temporary operation of the zone through DADS would be what would need to advise the police, because Ms. Carter, who's also present, will not be able to operate beyond this Friday. So beginning on Friday night, I guess at midnight, or whatever time is, we'll have to notify the Emergency Communications Center that there will be no call sent to Carter and it'll need to be sent somewhere else. It seems appropriate to allow DADS to go ahead and to back them up, and then it'll be a full hearing. People will need to apply 15 days prior to the next meeting in order to be considered for the zone transfer.
So we do need a motion to just temporarily, in this interim period, to assign the zone to DADS towing service.
I make a motion to temporarily, in this interim period, assign the zone to DADS towing.
Second.
All those in favor?
Aye.
Motion passes. Thank you.
Thank you very much.
Next, we have a driver application for Joshua Cone. Mr. Fields?
Mr. Cone has applied to be a record driver and would actually be working for DADS. In making his application, he had a lengthy disclosure of his driving background. He's had some problems driving, but nothing that would disqualify him. It just meets in normal fashion. If you would like to, you've asked me to anything that was excessive that you'd like to review it. But as we've reviewed it, there does not appear to be anything with prohibit him from being a driver, other than your conversations with him about his driving skills.
It looks like you were cited for failure to pay your traffic tickets
Yes, sir. That's
last year.
Yes, sir. I've already paid all that. Since then, I've gotten a CDL, so permit.
Yeah. And the CDL is a much more restrictive permit than the others in terms of if he's from a qualification standpoint. So there's certain things you can't, for instance, if you get a ticket with a CDL, you don't go to traffic school. You lose, that's not an option. And I assume you could approve him and restrict him to dads.
Dad, do you know this gentleman?
Sir, he's actually done labor jobs for me for 2 weeks. 2 weeks, but he's not driven one of my vehicles at all, but he's done manual labor jobs for us. We, of course, clean up a lot of yard work that we were massively behind on, weed eating, just absolute physical jobs, and he's done a tremendous job on it. He's not failed to be on time. He's not given me any reason to doubt him. As all my drivers, y'all know I'm pretty careful about my drivers. I've actually followed him when he never knows I follow him, but I follow every one of my drivers at least once a month to see how they're driving and see what they're doing. And I've been behind him when he never knew I was behind him. He's a good driver. He's a very, very respectful driver. I think the situation, if you really look at this, he got into a little deal where he got a ticket and just did not have the money to pay the fines at the time. And he got several problems getting his money up to pay the fines. And he does have, I think, overall in the several years, 2 tickets?
Mm-hmm.
And
it's been a while.
One of them was quite a ways back.
So upon approval, you're prepared to offer him a driving job?
Absolutely, with our training. He has to go through our training course first.
Mr. Cone, I've seen this happen many, many times, including to many people that I know. When you get that ticket, and you don't pay the ticket, and then you get a failure to appear, and then next thing you know, you've lost your license for 6 years. So the lesson is, if you get a ticket, you better tell him right away and do what you need to do.
In the past, it's just been times I didn't have the money to go pay it whenever I just got it, and that's why they'd get suspended or something like that. But if I got pulled, if something happened, I got pulled over, I'd go right then as soon as I get the money and I'd have my license before court, and they'd dismiss it. So I've always made sure that I've had it taken care of.
When did you get your CDL?
A second, I'll tell you. 6/20 of 19.
Oh, okay, so just recently.
Yes, ma'am.
Congratulations.
Thank you.
And as y'all know, a CDL is not that easy to obtain these days.
Exactly.
Do they not care?
They want that deal, didn't they want that money from the go?
I'll make a motion to approve the application with Mr. Cone driving for restricted to dad's service only.
If you don't mind, I would like to have you restricted to dads in West Nashville if possible, because we do great
Dad's
things
in
back
West
there.
Nashville, even better. That's
We are
perfect.
our own backup, so that way it helps me to be able to keep them busier and make
Is
them
that Dad's in West Nashville or Dad's and West
Yes,
Nashville?
and West Nashville.
And West Nashville. And do you own that as well?
Yes, ma'am.
Okay.
Do you have a time period you'd like to have him restricted? Unless you say normally I restrict it for a year, unless you have a specific time period.
I'll say 1 year unless anyone disagrees. Okay, 1 year. Restricted for 1 year to Dad's and West Nashville towing.
I second the motion.
All those in favor?
Aye.
Motion passes. Thank you.
Thank you. Appreciate
Thank
your
you.
time. Thank you.
Next, we have 2 company applications for other passenger vehicles for hire companies. The first is MJR Speed LLC, and then also Tazi Alamayehu, DBA Taz Limo. Mr. Fields?
Well, their applications, in order to be approved, they have to be presented to the commission. Both are in order. You can.
Make a motion to approve Taz Limo and what is this?
MJR Speed LLC.
MJR Speed LLC.
Second?
All those in favor?
Aye.
Motion passes. We do have some other business as well. We have a green cab certificate of public convenience and necessity status report.
Green Cab contacted the office and has determined to close. They have closed their business and surrendered their certificate back to the commission. We have the documentation for that. And I think they're in bankruptcy. So there's no action that's required of the commission. They obviously have the right to surrender. I guess we could accept the surrender if you wanted to accept it. But that's about all I think that's left to do on that.
Unconditional surrender.
Well, pretty much. They're one of the newer companies that we brought on board, I think, in 2013, when we had the great expansion of taxi cabs in Nashville.
How many cabs, just out of curiosity?
I think at one point it had, as many as 40, I believe. But and I think he'd gotten down to where it was under a dozen. So so basically the green cabs are supposed to be off the street. We're having some issues. We need to get the other cars transferred, but we're working on that.
All right, and then we also have one other piece of business. The ordinance for the SUMD, the substitute bill that was passed last week, unless the mayor signs it sooner, it goes into effect on August 6th. And I think we need to have a specially called meeting on the 7th of August so we can implement some interim rules to apply to SUMDs while we are working feverishly these next 100 days to get the RFP process underway and completed. Because right now, the way I understand Metro Legal has reviewed the substitute bill, there will be a very bare bones set of rules for the SUMDs to follow in this interim period unless we meet as a commission, pass some rules, and that will apply during this period. I think August 7th makes sense because it's the day following when the bill becomes law in Nashville. And if we wait too much longer, it doesn't make sense for us to not have some certainty on what the regulations are.
This room is available beginning at 12 o'clock that day.
Do we need to make a motion to call the meeting, or do we just set it?
Yes, I think it would be good to make a motion to call a specially called meeting.
What day of the week is that?
It's a Wednesday.
Okay.
Let me double check that.
August 7th, that's right.
August 7th is a Wednesday. And again, this room is available. August the 7th. And it would need to be a public hearing, so it would. Well, we're going to we'll be suggesting that you adopt many of the same rules that were in effect with the previous ordinance, as well as probably some modifications, and then anything that you choose to add, because not only is it working during the RFP, they would actually go forward beyond the RFPs being awarded later. Ms. Costones probably could explain that a little better than I from that standpoint.
Yeah, no, well, what I can do...
Would it work better for people to have the meeting later in the day than in 1:30?
Probably.
You're going to be in traffic either way.
Yeah, that's what I was thinking.
Well, we do have the room from noon until 5:30.
I'm not sure I can make that day anyway.
Wouldn't matter to me.
Hang on, I'm scrolling. I'm
We
going to read you the
need
language
your
about the
wisdom
interim rules.
and information. You have to make that.
I don't think I've had a second
It
for any
actually-
motion I've made yet.
But the
But you've had some
MTL, is what it
very
says, the MTLC is directed to immediately enact emergency regulations to govern the interim period of reduced SUMD fleet operations, because the bill also reduces the number of permits to 50%. in Metro, as well as operation after an operator has been selected pursuant to the RFP process outlined above. So basically, the rules are called interim rules, but they're saying they're going to be effective both during the period before the RFP is issued and afterwards.
Well, I would propose we start at 2:30. Since it's a specially set meeting, there's nothing else going to be on the agenda.
Is there nothing's
fine
gonna
with
get
me.
added to the agenda? So you're saying 2:30. So let me
Did
move
someone
that
make a motion?
2:30.
Oh, I'll make a
Not
motion. You meet at 2:30 on August 7th?
Notice he said you?
Well,
Not we.
I'm pretty sure I'll be going to Alaska, but I'll let you know.
Oh, wow.
I do whatever my wife tells me.
I second the motion.
All those in favor?
Aye.
Motion passes.
We're actually going to Alaska too.
I was sort of told I was going.
Hey, I don't argue with vacation.
All right. Is
Yeah.
there a motion to adjourn?
Make a motion
moved.
to adjourn.
Second.
All those in favor?
Aye.
Motion passes.
I think we all made that motion.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.